here. Turn off my camera.
Can you hear me?
I'm here.
Okay. Can you hear me, Joel?
Yeah, I've got you and my client's connecting.
Oh, okay. I see that. And Judge is on
He's on mute, so I guess we're in a
mute, I
holding
guess.
room.
Oh.
All right, the court is calling FM 18-338. We are on the court docket today for a motion for withdrawal of counsel filed by Mr. Elliott on behalf of Mr. Richard Scott Tyler. Can everyone see and hear me okay? Raise your hands. Okay. All right. And then Mr. Tyler, you're muted at this time, and Mr. Elliott and Ms. Thompson, you are not. So, Mr. Elliott, it is your motion. You may proceed, sir.
My client and I entered into a contract concerning services. The terms of that contract have not been met. Mr. Tyler and I have discussed this several times. Obviously, he's aware of the hearing today. He's here. I would just like to have the opportunity to be removed from the case. And I'm certain we have a hearing set for tomorrow. He would probably want more time to be able to retain another attorney. But that would be his argument today. But mine is that we have an attorney fee contract that has not been complied with, and he and I have discussed it at length. I don't think there's any animosity between the two of us. We just haven't had good luck on being able to comply with the terms of the contract.
What about the ground of being unable to effectively communicate? Is that still a ground in your motion?
Yes, my client recently, as far as responding to discovery, there's been some times that he's been working out of town, and it's been difficult for us to communicate. Mostly, I believe, based on his need to travel for work, but that has been a problem.
Ms. Thompson, would you like to respond?
Judge, technical issues, I missed a whole lot of that. I would say I have no opposition to Mr. Elliott's motion to withdraw. I've joined in today purely for the purpose of if Mr. Tyler is seeking additional time with respect to tomorrow's hearing, if the court grants Mr. Elliott's motion to withdraw, then I would say we don't oppose that and would be happy to look at dates. We do have extraordinary relief in place though at this point, and I would want Mr. Tyler to be aware that we'd be asking if that be extended and remain in place until he retains counsel and is ready for a new hearing if he is seeking more time.
All right, let me kind of pare it back to you what I heard, because there was some technical difficulties with what you said. I think what you indicated was that you are not in opposition to Mr. Elliott's motion to withdraw, that if Mr. Tyler wanted to retain new counsel for preparation for tomorrow's hearing, and if he requested more time to do so, that you would not be in opposition to that either. However, you would ask that the extraordinary relief be continued in that case until that new hearing. Is that right?
That's correct, Your Honor.
All right. And Mr. Tyler, do you understand the statement of Ms. Thompson? Do you understand what she's stated, that she's not opposed to?
Yes, I understand to the point, but to the other allegations that I have to be at court tomorrow, them are all.
Well, let's hang on, Mr. Tyler. Mr. Tyler, we're not going to talk about anything today other than Mr. Elliott's motion to withdraw. And so he's told me that he's filed the motion and he's asked the court to allow him to withdraw. And so your purpose of being here today is that you have the opportunity to be heard on whether or not you oppose Mr. Elliott withdrawing as your attorney. Ms. Thompson has responded to the court that she is not opposed to Mr. Elliott withdrawing, and she's not opposed to resetting tomorrow's hearing to give you more time to hire an attorney if that is what you choose to do. However, her non-opposition would be contingent upon the court extending the relief that had been granted to them in the temporary restraining order. So whatever's in place right now would be extended.
There's nothing in place.
Hang on, Mr. Tyler. I'm still talking. Okay, I'm trying to tell you what we're talking about today and what we're not talking about. And what we are not talking about are going to be the issues that the court's going to hear in regards to the temporary restraining order. Okay, so I need to know from you, one, do you oppose Mr. Elliott withdrawing as your attorney?
No, there are some other situations, as in I do have some funds, so I can give him more money. I have acquired $2,000
Well,
more
listen,
dollars.
I understand, but listen, I'm not here to be a mediator between you and Mr. Elliott on how much money you have and how much that's a private issue between you and he or you and any other attorney. If I want to know, are you opposed to him withdrawing as your attorney in this case?
If he chooses to, he can do that.
Okay, so now I need to know, are you requesting the court to give you an extension of time before we hear those issues on the temporary restraining order, which is set tomorrow? And if your request is to reset that case and give you more time to prepare for that hearing with new counsel, then do you understand that Ms. Thompson is asking the court to extend the emergency orders that were signed?
But there's no papers that are signed, and there's no papers that are signed. That's what I don't get. I haven't gotten no papers that are signed.
Ms. Thompson, what was the relief the court granted, if any?
The court signed an order, a temporary restraining order last week, prohibiting access by Mr. Tyler until a hearing can be had, and that is set for 11 a.m. tomorrow.
And Mr. Tyler, you have not received a copy of
I
those?
have gotten nothing with no signatures. It's the only thing that has on is Maggie's attorney, which is Thompson, I think it is, and Elliott has no signatures on it, sir. None.
Mr. Elliott, have you seen a court's order in this matter?
I have forwarded the documents that were sent to me concerning the temporary restraining order that is set for tomorrow. That's what he's talking about. It was whatever was filed with court. We forwarded it to him, let him know that it was set tomorrow, and then let him know at the same time that we were moving forward with the motion to withdraw. And we have not discussed tomorrow's hearing.
I have received no signatures of anything.
Give me just one moment. All right, Mr. Tyler, I'm going to display on the screen here the most recent temporary restraining order and order granting extraordinary relief. This is what Ms. Thompson is referring to. And you'll see here that the court signed that. Let's see here. Court signed that on that date and at that time. You have not received that, or you received a copy of this, but not signed.
I have gotten no signatures that has a time or date. I just received the papers 2 days ago, and that's all I have. I have no signatures. I was not served any papers of such thing. I just have blank papers.
Ms. Thompson, do you know if Mr. Tyler has been served with the temporary order?
He hasn't been personally served, Your Honor. We sent it through counsel.
And Mr. Elliott, you're saying you forwarded this copy?
Let me, if I can, give me just a second. I'm gonna pull up my. Well, now I'm not sure I can figure out how to get out of this.
Let me look at the papers again.
Judge, I can't see my hard drive, but whatever was sent to me, all we've done is forward everything to him, but he and I have not discussed it. And I can't figure out how to lower my screen.
All right, let's try something, Mr. Elliott.
Okay, now I can.
Let me, I'd like to put you and Mr. Tyler into a breakout room and let y'all have a conversation about this before we go forward, so that you can advise as to what the current orders of the court are, so that he can make an informed decision. Okay, so give me just one moment and let me see if I can't set this up for you.
I do have the papers right here in front of me.
Hang on, Mr. Tyler. Mr. Tyler, just 1 second.
Yes.
All right, I'm gonna send you over there at this time, Mr. Elliott, if you'll discuss with Mr. Tyler the current restraining order issued by the court.
Okay. Okay, okay.
Once that, you should have, each one of you should have received an invitation. If you click on that, it'll move you to that room and then you can exit when you need to. All right, and so what we'll do, Ms. Thompson, is I'll just stand in recess for just a moment. And so if you want to, you can stop your video or whatever. And then whenever we get back on, I'll make sure that we don't get started without you.
Okay. I don't have to do anything and then I'll get like an invitation to reconnect or something. I haven't ever
No,
stopped.
no,
one
you
before.
you shouldn't do anything because I sent an
I just,
invitation to Mr. Elliott and Mr. Tyler. And so they're now visiting in private in the same session. So
okay.
whenever they get through, they will rejoin us. But what I'll do is if you hit like stop, you hit stop share, you'll see how you can still hear me, but you can't see me. So
Right.
we are streaming. So if you want to turn your video off, you can do that. Otherwise, you can just sit there and wait for Mr. Elliott and Mr. Tyler to be back.
I'll just wait patiently so I don't
Okay.
have to mess up anything.
Okay. All right.
No
No
big deal.
problem.
Thanks.
All right. We'll be back with you in a second.
Okay. Yeah, that's fine.
I'm back. Can y'all hear me?
We'll stay off the record.
I'm back. He's trying to figure out how to come back in.
Okay.
He's using his cell phone.
Okay. I'll watch for him.
I told him, give it 60 seconds to figure it out. If he can't, then to click the link and try to log back in through the regular invitation.
Yeah, I don't see him in that. Let me see if he's in that breakout room. Yeah, he's back. Let's see, Richard Tyler. Let me close the room. If I close the room, he'll probably come back.
Okay, there he is.
And then we lost Ms. Thompson. Give her a second, she'll rejoin. All right, we're back. We're going to go back on the record. And Mr. Elliott, have you had an opportunity to discuss with Mr. Tyler the issue before the court at this time, which is your withdrawal of counsel and the continuance of the temporary restraining order that's set before the court? I believe it's set tomorrow at 11 a.m. and the contents of the current order issued by the court.
Yes, Your Honor. And I've gone back and looked at everything that was received from my office. We received everything. We received the motion to modify temporary orders, and we received the temporary restraining order. We received those before they were file marked. Since apparently they've both been file marked, the only one that we've received with an actual file mark on it with signatures is the motion to modify temporary orders. So in my inbox, we've received the unsigned temporary restraining order, but we have not received the actual file mark copy of that. And that's what I have forwarded to Mr. Tyler. But for some reason, the court, unless it just didn't get opened or something, it hasn't been received by me. I mean, we are aware of it, and we're aware that it's set tomorrow, and we've informed Mr. Tyler of that, but he hasn't seen the signed copy.
But he does understand that the court had signed that restraining order?
Yes, well, I don't know if he's aware that it was signed. He's aware that it's set tomorrow.
I've just seen that signed paper that the judges just showed me. Other than that, that's the first time I've seen the signature.
Well, the court has signed it. And so is Mr. Tyler aware of what the court granted?
He has seen the document, and he knows now that it has been signed by the court, yes.
Okay. And so, Mr. Tyler, then we're going to go back to that question at hand is, do you want more time to prepare for the hearing on the temporary restraining order and motion to modify tomorrow? And if you do you understand that Ms. Thompson is going to be asking the court to extend its current order?
You know, as long as what I read right here, there's nothing to do with visitations or phone calls. Sure, she can have the restraining order on her because I want not to be around her. So if she doesn't have one, I'm gonna file one myself. You know, because I don't need to be around her because of the allegations that are set for me 2 days ago of these in these papers. I don't need to be around. I don't want to see any kind of people like that. You know, so if she wants a restraining order, fine. That means if it means that I don't have to get one and she can stay away from me, fine. And I'll deal with this, you know, deal with the other two, you know, tomorrow, you know, if that's what it amounts to, you know what I'm saying? Because,
well, I don't want to assume that you know what it amounts to, so let me show you, and then you can read it for yourself. I want you to read right here where it says additionally, based upon the information, I want you to read that. That would be the order that Ms. Thompson is asking the court to extend.
Okay. Based on, oh yeah, based upon the information forth and supporting this, start hereby adjourned from any unsupervised. I'm not agreeing to that.
Okay, so, all right, so then you're asking the court to allow Mr. Elliott to withdraw, and you're going to appear tomorrow and have counsel ready to take this matter up?
I won't have counsel ready, but I'm not agreeing to that.
Okay,
You know,
I'm telling you, Mr. Tyler, that what's going to happen then is we're going to show up to court tomorrow and you're going to represent yourself.
well, if I ask for more time, if I ask for more time to get counsel, then does this come in effect?
This is already in effect.
Really?
Yes, that's what I'm trying to explain to you, Mr. Tyler. Look, you see right here, the court,
Yes.
June 19th, 9/18, and I understand that you didn't get a copy of it. Mr. Elliott explained that to me. But I signed that order on that date. That's in effect right now.
I don't understand how it's in effect because
Well, I understand, Mr. Tyler, and it's not my job to explain to you right now how it's in effect. Ms. Thompson had applied for it. They provided information and affidavit. The court reviewed that information, that evidence, and granted the order. That order is in effect until we have a hearing on this matter. If the hearing tomorrow is reset or continued for you to get a new attorney or to represent yourself, any continuance in this matter is going to have this order extended until we have a hearing in the matter. So if you're not agreeing to it, that's fine. You don't have to. Then tomorrow we'll appear. I'll expect you to be here and we're going to take this matter up because that's when it's set. Okay?
Yes, I'm not letting that fly, even if I don't have a lawyer. I mean, because it's nonsense, you know?
Okay.
I'm sorry. I've already went enough time without seeing my daughter. I'm not agreeing to anymore.
I understand. All right. So then the court, let me stop this here. All right. So the court, after considering the motion of Mr. Elliott and the consent offered by Mr. Richard Scott Tyler, the court hereby grants Mr. Elliott's motion to withdraw, and also the court takes into consideration no opposition by opposing counsel, Ms. Thompson. Court hereby allows Mr. Elliott to remove as counsel in this case, and Mr. Mr. Tyler, the hearing is then scheduled still for tomorrow at 11 a.m. So the court will expect you to be here with either new counsel or you may proceed by representing yourself, okay? Hang on, let me unmute you. Go ahead. Just 1 second.
I got it.
All right, so you understand that?
Yes, I understand that. So this is just under this, and I mean, I understand. And it's just over these three things, correct?
Well, you'll need to see that motion. You'll need to see the motion to modify, and then you'll need to see the temporary restraining order.
Okay. And I just tell you what I have to say, and then you make the decision, correct?
I can't advise you. I can tell you that if you're going to represent yourself and you want to bring evidence to the court, then that evidence will need to be properly admitted under the rules of evidence. So it's not as much as you just telling me what you want to tell me. If you have personal knowledge or you have evidence that you can offer through your own knowledge or own, what I'm trying to tell you is you can't just say, someone said this, someone said that. This is what.
Of course, but CPS wants a call from you. They won't give me anything. CPS wants a call from you, and they will discuss it with you that there's no safety plan. There's nothing. So there's.
Well, let's don't get into the hearing today. So
Okay.
I'm not calling CPS. Don't get up here and expect me to pick up the phone.
Oh, okay, but
That's
they
not
won't
how it
give
works.
They won't give me anything until it's over, and that's 30 to 60 days.
Then
So,
I suggest that you get on the phone with CPS now and try to get any evidence that you want to bring to the court, and then bring it to the court tomorrow at 11. But don't ask me to get on the phone and start calling people because I'm not your attorney. Okay.
Thank you.
All right. We'll see you tomorrow at 11 a.m. Mr. Tyler and Ms. Thompson.
Thank you.
All right. Thank you, Mr. Elliott. All right.
Thank you, Judge.
I will conclude this hearing.
Thank you, Elliot.
You're welcome.
Ciao.